Okay, welcome to Class 5 of Intellectual Property. We're going to continue our discussion or conclude our discussion of trade secrets in this lecture, in which we talk about misappropriation of trade secrets, or the standard for determining when the acquisition of the trade secret information by the defendant is actually an infringement of trade secret protection. So in previous classes, we've been talking about whether or when information is a trade secret in the first place, what the obligations of a trade secret plaintiff are to show that they exerted reasonable efforts in protecting the secret. And in today's class, then we're going to talk about what constitutes improper behavior or misappropriation on the part of the defendant. So obviously, as with other trade secret laws, there are differences between state and federal standards and between different states. But broadly speaking, we can see this kind of standard definition of misappropriation, lots of different contexts in which misappropriation can occur. Key concepts are the requirements of both knowledge and improper means. So the defendant has to both know that the information is secret and know that the information was obtained by improper means. Notably, that means the trade secret action can be brought against both the misappropriator and the recipient of the misappropriated information, which should be apparent when you think about some of the cases that we've discussed. And obviously, in many cases, trade secret protection would be much less appealing if you could only bring an action against the misappropriator and not against the ultimate, presumably competing recipient of that misappropriated information, who's really the person that the trade secret owner is concerned about in the first place. So we'll start by looking at the DuPont v. Christopher case, which is a really iconic one from quite some time ago. Essentially, what happened in DuPont v. Christopher was that DuPont, a giant chemical company, was developing a new secret but unpatented method of generating methane on this factory, at this factory in Texas, where they had a whole bunch of different petroleum factories engaging in different kinds of industrial processes. And presumably a competitor, but somebody, we don't know who, and it's never been really disclosed, somebody hired the Christophers, who are aerial photographers, to fly around over this particular DuPont factory and take aerial photographs from above of what the factory was doing, presumably in order to learn what they could about this secret method of producing methane on the basis of aerial photographs of the machines or the processes that DuPont was using. In any case, DuPont saw the airplane flying around over above, got suspicious, and sent people out to apprehend the airplane when it landed, and insisted that the Christophers, turn over the photos, tell us who hired you to do this. The Christophers refuse, and DuPont brings an action against the Christophers in district court, alleging trade secret misappropriation. And the Christophers respond by filing a motion to dismiss, right? Essentially, they say, you have an alleged trade secret infringement claim against us. Why not? They say, you haven't alleged any kind of misappropriation, because misappropriation requires improper means. And we haven't done anything improper. We flew up in an airplane. We're allowed to be in an airplane. We flew over your factory. We're allowed to fly over your factory. We took photos. We're allowed to take photos. We didn't do anything wrong. You can't bring a trade secret action against us on those grounds, right? There's no trespass of any kind, right? We're allowed to do everything that we did. So there was no violation of physical property law. And we don't have any confidential relationship with you. We don't have any obligation to maintain any kind of secret for you. Therefore, you can't bring this action against us for engaging in improper behavior. And the district court denies their motion to dismiss. And the Fifth Circuit affirms. What's interesting is why it affirms. Right. So the district court begins by essentially saying, is this a trade secret? Well, yes, it's a trade secret, right? It's secret information about a new process that DuPont is developing. And it's valuable, at least in part, because it's secret, right? It enables them, or hopefully will enable them, to compete more effectively with other chemical companies, right? Are they using reasonable efforts to maintain secrecy? Well, it's on a fenced in factory lot. They've got walls up and everything like that. The district court says, yeah, I mean, this looks prima facie reasonable efforts to maintain secrecy under the circumstances. So the key question here is, did the Christophers engage in improper means? And the court says yes. Right? And why does it say yes? Well, essentially what the court's conclusion here is that, look, we all know that what you're doing is industrial espionage, right? Somebody hired you to fly over the DuPont factory to take photos of this process. The only person who would hire you to do that, presumably, is a competitor who wants information about this process. That's industrial espionage. You're not supposed to do that. That's bad, improper behavior. We don't like industrial espionage, right? To the response, the natural response being, well, isn't it on DuPont, right, to prevent this kind of industrial espionage from taking place? And the court says no, right? DuPont has to take reasonable methods to prevent the information from being available to anyone who wants to see it, but they've done so, right? Reasonable methods, according to the court, involves putting up the fence probably, or having a building. But reasonable methods, according to the court, does not mean having a roof over the building, presumably because either DuPont didn't expect or shouldn't have had to expect or defend itself against the possibility of somebody flying over the plant to take photographs. Essentially what the court said is, look, would it have been possible for DuPont to have protected itself against this eventuality? Probably yes, right? They could have done more to protect the secret in question, but they shouldn't have to, right? And it was improper for the Christophers and for the people hiring the Christophers to circumvent the means that DuPont had reasonably used to protect the secret under the circumstances, right? Okay, so fast forwarding to quite a few years later in the Silco v. Intel case, what happened here? Well, Silco makes electronic design automation software for the purpose of manufacturing semiconductors. Essentially, it's software that semiconductor manufacturers use in the process of making computer chips. Obviously, Intel is in the business of making semiconductors, making computer chips, and it uses electronic design automation software to make those chips. Okay, so Silco brings a trade secret infringement action against one of its competitors, Circuit Semantics Incorporated. And the action is for misappropriating a trade secret that Silco has integrated into its software called Smart Spice. And essentially Silco says, you have used our trade secret, Smart Spice, you've misappropriated that trade secret into your DynaSpice product. Previous action, Silco is successful in this action, right? It prevails in a trade secret action against CSI for its DynaSpice product. And after it wins, it then brings an action against all of the companies that use its competitor's product. Basically, it goes after all of CSI's customers and says, if you've used this CSI DynaSpice product, you too have infringed our trade secret. How have you done so? Well, you've infringed our trade secret by using DynaSpice in designing your integrated circuits. Essentially, Silco's position is, look, the software incorporates the trade secret, thereby by purchasing the software and using the software, you have also used the trade secret, right? If the software depends on the trade secret, then using the software means you've also used the trade secret, right? This trade secret that's built into the source code of the software. Now, understandably, the court is a little leery of this argument being levied by Silco, and points to the source code of the software as being where the trade secret is embodied, right? So the fundamental question here is, can Intel and the other integrated circuit companies be liable for trade secret infringement merely because they used a trade secret infringing product? The court doesn't want to say yes, and ultimately it finds a way of saying no by saying, look, the problem here is that the trade secret is baked into the source code of the software, but Intel didn't have access to the source code of the software. Right? The source code is what's written when the software is created and then compiled into the program that's ultimately put into practice by the end user. Now, did the source code make the program work? Well, presumably, right? But Intel didn't have access to, and frankly, wasn't interested really or necessarily in the source code at all. What it wanted was the product that resulted from the source code. And it didn't use the trade secret merely by using the program, nor did it acquire the trade secret if it had no idea that there was trade secret information involved in the first place. After all, Intel never had access to the source code and presumably didn't want access to the source code, or at least didn't need it for their own purposes. Furthermore, and perhaps equally important, the court observes that Intel didn't do anything improper under the circumstances. Essentially, it says, look, there was no improper behavior on the part of Intel, and therefore no basis for a trade secret action.